Good morning, everyone. Welcome to the Judiciary Committee hearing this Thursday morning at 10:30 and 016. I hope anybody can hear me because, okay, there we go. This meeting in the YouTube live stream event is for the Judiciary Committee's 10:30 a.m. agenda on one appointment to the District Court for Kauai and two appointments to the District Family Court for Hawaii Island. And can everybody hear in the back? Can you hear? A little louder. All right, I'll try. Okay. The other members of the Judiciary Committee are Vice Chair Keio Kalole, Senators Ocasio, Gabbard, Lee, Kim, and Favela. This hearing is being streamed live on YouTube. You can find links to viewing options for all Senate hearings and meetings on the live and on-demand video page of the legislature's website. If you're interested in seeing the written testimony, you can go to the legislature's website at capitol.hawaii.gov. In the unlikely event that we have to end abruptly due to a major technical difficulty, the committee will reconvene to discuss any outstanding business this afternoon, June 16 at 3 p.m. in this room 016 and via video conference, and a public notice will be posted on the legislature's website. For those testifying remotely, all testifier audio will be muted and video disabled until it's your turn to testify. And there is a 2-minute time limit per testifier, although members often do have questions. So if you can hang around, that would be great. If there are temporary technical glitches when it's your turn to testify remotely, we may have to move on to the next person due to time constraints, but we'll try to get back to you if we can resolve the technical difficulties quickly. And we do have your written testimony. Okay, and for members and everyone else, we won't be voting today. We'll vote on Monday at June 20 at 11:30 a.m. in this room 016. Okay, first up today, we're going to do this in reverse numerical order. Today, it will be Judiciary Communication number 3, Gregory H. Myers, submitting for consideration and confirmation of the District Court of the Fifth Circuit for a term to expire in 6 years. First up on the testifier list for JC3 is Thomas D. Farrell, who I believe is here. Yes, good morning.
Morning, Chair, members of the committee. I'll fill out my written testimony in support, and I'll be available to the committee if there are any questions I can answer, particularly in view of some recent developments after my testimony was written today.
Okay, thank you. In support, Monica Trask on Zoom, maybe.
Aloha, Chair, honorable committee members. Can you hear me?
Yes, loud and clear.
Thank you. For the record, Monica Trask. I'm speaking today in support of Mr. Myers' nomination and appointment to the bench, the Family Court of the Fifth Circuit of Kauai. I've known Greg for nearly 20 years now, both professionally and personally. When I was a deputy prosecuting attorney and then ultimately first deputy prosecuting attorney under the administration of Craig DaCosta, I found Mr. Myers to be amicable, good temperament, intelligent, and ethical. I have heard about some recent issues regarding him that have been brought forth. I don't know anything about them personally or firsthand. I did attempt to figure it out. I contacted the prosecutor's office, both the prosecutor, Ms. Vogt, and the first deputy. They did not share any information with me. I do understand that statements have been made in public, and there will be made today, so I was kind of taken aback why it wasn't shared with the legal community. And although I can't speak directly to those allegations, I have been a criminal defense attorney and a prosecutor, and from what I've heard, it doesn't seem to me that the allegations warrant any concern. In fact, they seem to me like that's ethically what Mr. Myers has to do, is speak to witnesses, including complaining witnesses, as in order to represent his client. But beyond that, Mr. Myers does have my support, and that's all. Thank you so much. If you have any questions, I'm happy to answer them.
Great, thanks. We will go through a few more testifiers, but if you could hang around for questions, that would be great. Daniel Hempy. I'm sorry, Hempy. Good morning. You're muted. There you go.
Oh, thank you. Thank you. Yeah, I'm Daniel Hempy, and good morning, everyone. I also support Chief Justice Rechtenwald's nomination of Greg Myers wholeheartedly. I've known Greg for 20 years, was law partners with him for many of those. And I want to start, I'm rather aware of the situation that's come up lately, and that's why I signed up yesterday to testify. I agree with Mauna Kea. This should have no concern for the committee. And I want to start by saying that today in Russia, I expect that a government prosecutor is having a defense lawyer arrested for contradicting the government's narrative. And as I understand this last minute smear, I'll say, I understand that Mr. Myers is being accused of talking to a witness who had made a previous statement to the police before charges were filed. I understand he talked to this witness. And here in the United States, when a government witness is found to be telling two different stories, it's the defense lawyer's moral and ethical imperative to discuss it with that witness. A simple Google search of can a defense lawyer talk to a prosecutor witness yields pages and pages about the obligation of a defense lawyer to do so. And in fact, Rule 3.4 of the Rules of Professional Conduct actually prohibits a prosecutor, any lawyer, from obstructing a lawyer's access to evidence, and that includes witnesses. And when a defense lawyer finds out a government witness is told contradicting stories, I can think of nothing more obstructive than the prosecutor calling the police or filing an ODC report or a June surprise 6 months later as that lawyer is about to be nominated to the bench, not against the lying witness, but against the lawyer who took the statement from the lying witness. In jurisdictions with a competent prosecutor, a prosecutor takes that statement gratefully, reevaluates their case, or hires an expert.
Thank you very much.
Contradict it.
2 minutes has expired. Next up is Michelle Primo. I'm sorry, I'm probably butchering your name. You're muted though. I still don't know how to pronounce your name.
You pronounced it perfectly the first time. Good morning,
Okay.
everyone. Thank you for allowing me the opportunity to testify. Like Mauna Kea, I have worked with Mr. Myers both as a prosecutor and Mr. Myers being a defense attorney. I have worked with Mr. Myers as a defense attorney. I have had Mr. Myers as opposing counsel in civil cases. I currently have Mr. Myers as an opposing counsel in a civil case. Mr. Myers has always been civil, highly competent, and his ethics are unimpeachable. From what I understand of the allegations, and I have spoken to multiple people about it, this frivolous police report that was filed by a deputy prosecuting attorney appears to be an attempt to scuttle Mr. Myers' nomination and furthermore intimidate the defense community. The defendants have a right to due process, and as part of that due process rights, attorneys need to interview complaining witnesses and prosecutors' witnesses. Now, allowing Mr. Myers' nomination to be scuttled because of this police report could have a very hard chilling effect on the defense community. We're always going to have to be looking behind our back when we zealously advocate for clients, as is our duty under the law, to worry if a prosecutor with a judge is going to try to send us to jail. Frankly, that's terrifying for me. And a culture at the prosecutor's office that allows this to happen is basically saying that defendants shouldn't have any rights. You know, what Mr. Myers did was ethical. If he hadn't done it, it would have been ineffective assistance of counsel. When you have complaining witnesses making multiple statements, it is quite literally the defense attorney's job to get a statement from that complaining witness.
Okay, thank you very much. Next is Alfred Castillo Jr. Good morning.
Am I on now?
Yes, go ahead.
Okay, thank you. Thank you for allowing me to testify today. Just a short background. I've been practicing law here since 1982. And, you know, I'm a former prosecutor for 15 years, former county attorney. My letter to your committee speaks for itself. What is problematic here is you have a last minute attempt to derail Greg Myers' process in becoming a judge. A police report has been filed. I understand an ODC complaint has also been filed, and basically we are all innocent until proven guilty. I don't know how far these complaints will go, but if you look under the statutes of tampering with a witness, you look under the statutes of intimidating a witness, I have in my possession a standard declined prosecution letter that I got from the prosecutor's office. And when a complaining witness comes to me and tells me, I want to drop the charges, and I basically determine if it's voluntary, and if it is, then I say, well, this is a standard prosecution decline letter that comes straight from the prosecutor's office, and I've used this letter for a long time, and it's no different from what Greg may have done. So basically, I wasn't going to testify. I wasn't going to submit any letter to the committee, but having heard the other night as to what the prosecutor's office has done, really bothers me. Really does. Thank you.
Thank you. Next is Craig DaCosta. Good morning. Still muted. There you go.
Good morning. Thank you for the opportunity to address the Judiciary Committee on this issue. As my letter stated, I've known Mr. Myers for 20 years. We've been adversaries. We've been colleagues. We have been law partners for a brief period. And then when he returned from Michigan, again, we remained colleagues. He is ethical. He is diligent. He has a proper temperament to be a judge. The rest of my letter speaks for itself, but I did want to share a little bit about my experience, similar to Mr. Castillo. And excuse me, I worked at the prosecutor's office for 12 years, 4 years as a deputy prosecutor, 4 years as the first deputy prosecutor, and then the elected prosecutor for 1 term or 4 years here on Hawai'i. When I first received any type of communication from a complaining witness recanting their statement, I was probably within 1 year of practicing law as a deputy prosecutor. I looked into it, determined that the letter was proper, seemed to have been an voluntary statement, and it pretty much sunk the case for the prosecution, but prosecutors are to do justice. And given that, we worked something out. It's happened many times in my career as a prosecutor. And since I've been on the criminal defense side for the last 14 years, I have quite often, as Mr. Castillo described, taken statements voluntarily from complaining witnesses. It's the ethical duty, an essential part of our job to do so and to document it. And it does not require an investigator. It can be handled by the attorney, just realizing the limits it will have should there be a trial.
Okay, thank you very much. That's all the testifiers we have in person or on Zoom. So I think I'll break at this point and allow members to ask questions of the Zoom or in-person testifiers. Members?
I have
Vice Chair, go ahead.
I guess this is just a maybe
Did I miss
question
somebody?
for
Oh,
the,
I'm sorry. Give me 1 second. Sorry, Vice Chair. Matt Bracken was also on the, there you are. Go ahead. I'm sorry. I didn't mean to miss you.
Thank you very much. Good morning. Matt Bracken for the record. I'm currently employed as the county attorney of the county of Hawai'i. I'm here personally. I am testifying in support of Greg Myers. I've known him for about 9 years. I originally interacted with him when I was originally clerking at the 5th Circuit. And, I always found him really easy to work with. He was always, he responded quickly to anything I ever needed to help the judge. When I started working for the county, he was always on the other side of the cases. He was always opposing counsel. He was always easy to work with. He's professional. He advocated for his clients, but a lot of, when we could work something out to the benefit of both of our clients, we always did. He was easy to work with. He does have the proper temperament to be a judge. I've read a lot of his his writing, of course, his motions. I've responded to them. I've seen him argue orally in civil and criminal matters. I do think he has temperament, and I do think he would be a good judge. And I felt it necessary to come and testify today. I can't say I'm very familiar with everything else that is happening. I've spoken to Greg about it, and I trust him, and I trust what he told me. And I do think he would be good, and I think that the Fifth Circuit would benefit with him being on the bench. I just want to share that. And thank you very much.
Thank you. Okay, sorry, Vice Chair, go ahead.
I guess just a point of clarification, Chair. That the majority of the testimony has been in regards to allegations that we don't have any details on. I did not see anything other than a notification that there were investigations in the testimony packet. Was there some other information provided related to the subject matter? Because otherwise we're lacking context here about what everyone, well, what many of the testifiers have alluded to.
Yes, that's a fair point. Yeah, there has been an ODC complaint filed that tracks what the testifiers have said so far. I was thinking in terms of allowing the nominee to talk about it in more length. I suppose it's kind of an unusual situation in that regard. Why don't we just go ahead and address that right now? This is a little abnormal for us, but
One question real fast.
Yeah.
Do we know when the date, when the allegations or the,
the ODC complaint was
ODC.
filed on Monday.
Okay.
And we didn't get it until yesterday. So,
Okay.
I'm sorry.
that's,
Okay, yeah. Okay. Let me just run through the other testimonies and the ones that have just written in, and then the bar is here, I believe, and they can speak to, and then we'll hold on Zoom. Okay. So I think it will become clear fairly quickly, but it's a good point. Let's see, we got Mel Raposo in support, Mary Frances McDonald in support, Megan Dietz in support, Ryan Mackey in support, Bentley C. Adams III in support, Mark L. Bradbury in support, Liz Grout in support, Russell Merlin Link in support, Colin Marty Fritz for Fritz and Trekker AAL in support, Glenn T. Hale in support, Mark Hubbard in support, Joseph Anthony Stewart in support, Michael Scarbo in support, Dennis Potts in support, David Kimo Frankel in support, Gerald Yamamoto in support, Franco Hay in support, Michael H. Kobayashi, President for Kauai Credit Adjusters in support, Richard H.S. Singh in support, David Hayakawa in support, Dalen Yanagita, Board Chair for Junior Achievement of Hawaii in support, Kurt Bosshard in support, Nalani Fujimori Kaina in support, Brian Curl in support, Rocco Neal April in support, Laverne Bishop in support, Janet Nathanson in support, Mark Murakami in support, Charles Foster in support, Greg Takase in support, Shailene Isari in support, Rosa Flores in support, Emmanuel Guerrero in support, Rico Ayabe for Hale Opio Kauai in support, Walter Rodby in support, Kai Lawrence in support, Tom Tanimoto in support, Justin Kohler in support, Michael Ching in support, Noah Gibson in support, Robert Jens Christensen, Deputy Prosecuting Attorney for Kauai in opposition, Crystal Glendon in support, David Mankin for McCorson, Miller, Mukai and McKinnon in support, Sean Hartley in support, Frederick Louis in support, Miles Briner in support, Kainani C. Alvarez in support, Ian K. Jung in support, Daryl W. Kanashiro in support, Shanti K. Manzano in support, Colby Y. Ionin in support, Matthew Manisto in support, Cynthia Ionin in support, Max W. J. Graham Jr. in support, Dodd Apau in support, Robert Lansdale in support, Luke Evslin in support, Randall J. He in support, Elizabeth Steiner in support, Nathaniel Evslin in support, Addison Bonner in support, Laura Barzilai in support, David Morantz in support. And that brings us to the Hawaii State Bar Association, I believe is on Zoom.
Good morning. Yeah. Good morning, Senator Rhodes. On behalf of the Board of Directors for the Hawaii State Bar Association, we stand by our testimony determining Mr. Gregory Myers as qualified, and I'm available for questions.
Okay, thank you. I don't know what's the best way to do this. can I ask a question of Ms. Sheldon first? So when did you, as I mentioned, the ODC complaint was filed on Monday. And when did you meet with the nominee?
We met with the nominee 2 days ago on Tuesday.
Okay.
Let me back up. Per our board policy, I and the executive director met with the nominee via Zoom on June 13th to discuss the subcommittee's findings. And then we, as a board, met and interviewed Mr. Myers on June 14th.
Okay. And you were aware of the ODC complaint at that point?
The HSBA board was made aware of the ODC complaint as well as the police report on June 14th.
Okay.
Immediately prior to interviewing Mr. Myers.
Are you at liberty to say what the gist of the complaint was?
I'm sorry, I'm not at liberty to reveal what was told to the HSBA or at liberty to explain the details of any of our deliberation regarding the report.
But you deliberated after you were aware of the at least the you deliberated after you're aware of the complaint and its contents.
Yes.
Okay. And you went ahead and called it and declared them to be qualified anyway.
Yes.
Okay. All right. So here's the part I'm going to take out of order. So Mr. Meyer, why don't you come on up and let's talk about this now. If you could just from your perspective, run through what you believe the complaint against you is and why it is you, I mean, my understanding is you believe that it's not, you did not commit an ethical violation. You can just explain why.
Sure. Thank you. Thank you, Chair. Thank you, committee members. My understanding, a complaint was filed against me based on talking to a complaining witness in a criminal case. This occurred prior to my client being charged with a crime, but after he was arrested. I was told that he wanted to talk to me because he wanted to withdraw his complaint. And so my client got him on the phone and I talked to him. I didn't really say much of anything. Actually, I listened to his story and took notes. And that's it. That's the last time I ever talked to the individual.
When did that occur?
That was December, I want to say December 18th, 19th, somewhere in there. I can't remember the exact date that I spoke to him, but somewhere in that third week of December.
Okay. And then what happened?
And then after that, within a few days, my client asked me to memorialize the notes that I took. And I did that. I sent an email to my client memorializing the notes that I took. And a few days later, my client brought me in a handwritten statement by this complaining witness. He told me it was by the complaining witness. I don't know because I never had further communication with the complaining witness. It was signed. At that point, I was ethically obligated to turn that handwritten statement over to the prosecutor's office. And that's what I did. And
when was that approximately?
I want to say that was that handwritten statement. I looked at my notes. I think it was December 21st is when that handwritten statement was signed. So I would have handed it over somewhere around then, within a few days of that.
Okay. All right. And then what happened after that?
After that, I entered into, after that, again, this was all before any complaint was filed against my client. After that, I had discussions, I believe, with the prosecutor, letting him know that I sent this statement. In January, they actually filed a complaint against my client. Then we had discussions with the prosecutor. Again, I never had any further communication with that complaining witness. I had discussions with the prosecutor. This prosecutor that is complaining was not part of the case at that point. We had demanded a jury trial and the case was moved up to circuit court. And that's when it was handled by the first deputy prosecuting attorney. Him and I reached an agreement. And in April, my client entered a plea to disorderly conduct as a violation, which is not even a crime, essentially a ticket. And that's the last I heard of this case until 2 days ago when it was brought to my attention by the HSBA that there was a complaint being filed against me. Okay.
And so what is it what's your understanding that the complainant believes is the unethical thing that you did?
It's my understanding he believes it's unethical that I spoke to the complaining witness. It's my understanding he believes it's unethical. That's it, I think. It's unethical that I spoke to the complaining witness. And they're also saying that I wrote some kind of statement for the complaining witness. I believe that's part of what they're arguing. is what I did inappropriate.
Is that unethical?
I don't believe it's unethical, but I also don't believe that's what I did. I memorialized my notes and sent an email to my client.
But talking to the complaining witness, is that unethical?
This would be the first I've ever heard of it. You heard from my peers. I believe that HSBA members that are criminal defense attorneys looked at this issue. I've never known it to be unethical. To me, would be a little bit strange if only the one side is allowed to talk to witnesses. I think it would be malpractice of me not to talk to a witness who is volunteering that they want to withdraw their police report.
Okay. All right. Does that give enough context to ask intelligent questions at this point? Okay. Why don't we open up for questions for either testifiers or for the nominee on this topic, and then we'll come to your openings.
You want me to stay here?
Go ahead and stay there. Vice Chair, did you have anything? Did you?
I actually have a question for the judiciary, but I know they didn't participate.
I don't know. Do you?
Rod, can you take a question? More than one question.
Move the mic.
Just slide the mic over. Yeah, that's fine.
Thank you, Rod.
Thank you.
Good morning.
Is
Chair.
there a precedent? I guess this is more a question for the committee, but from your experience, is there a precedent around a judicial nominee facing an active ODC complaint or under criminal investigation during their nomination process?
Has it happened before is what you're asking?
Yeah,
Not on my watch as administrative director of the courts.
because I can't recall one either, but I haven't been here that long. What is the judiciary process regarding a seated judge if they were subsequently charged or convicted of a crime or disciplined by ODC for actions that were taken before they were confirmed?
Okay, my understanding, and we researched this, so I'm able to give you.
Sorry, can you? I can hear, but I'm not sure everybody else can. Can you just pull it more directly to your? Yeah. Okay. Thank you.
We did research it, and we believe that there are rules of the Supreme Court. I believe it's Rule 8A6, which would allow action to be taken against a sitting judge for actions that would give rise to consequences that occurred before the judge became a judge. So in other words, if an attorney were to engage in activities that would result in disciplinary action, and the kind of disciplinary action that would make a judge ineligible to continue to be a judge, then that could be the basis for removal of the judge. So going from an attorney, you carry that responsibility forward on the bench.
And who would make those determinations?
It would depend on the sequence, I understand. So it might be the Office of Disciplinary Counsel, or it could be the Commission on Judicial Discipline.
Okay. If a nominee were under criminal investigation and subsequently confirmed and seated, well, I guess just in general, related to these inquiries, how might that impact cases that judge hears where this county prosecutor's office or the Kauai Police Department is investigating is involved?
That part I'm not sure, and I wouldn't want to speculate, but during the pendency of a charge, whatever the time that it takes to process that, and in a case like this, it might be where the county prosecutors have to refer either to another county or to the Department of the Attorney General because of the potential conflict. But that assumes that it gets to the point where consideration of prosecution is warranted. So there are a lot of steps in between.
What about the judge? Would there be circumstances in which the judge might need to recuse?
I would say in an abundance of caution, there could be. And I believe that for Mr. Myers, the position is family court.
It's definitely district court.
Family, yeah,
District.
district, but that's another area where the Chief Justice does have discretion.
But there is a likelihood that even if a nominee under inquiry or criminal investigation, the nominee is seated, there's a potential that individual would be unable to sit for cases because he might need to recuse himself.
I think that exists in almost any situation where a judge is looking at areas that could call into question the judge's impartiality.
But we're talking about the county prosecutor's office and the Kauai Police Department in this situation. So that seems like a lot of potential cases.
If I understand correctly, it was not the Kauai Police Department that initiated the report. I believe a report was filed with them. And that might be a distinction. As far as the Kauai County Prosecutor's Office, it's certainly a reflection, I think, of the sincerity of their belief that something occurred that requires further pursuit. But those two entities, the Office of Disciplinary Counsel and the Kauai Police Department, are responsible for making their own determinations and how to proceed from there.
Well, doesn't it seem like regardless of whether the allegations are true or false, if we proceed with a confirmation and the nominee is confirmed, there are still potentially many cases where we won't have a judge able to sit on Kauai.
I don't know that for sure. It's certainly possible that there could be cases where a judge would have to recuse themselves out of an abundance of caution. And there are per diem judges that can fulfill that responsibility. There are ways to adjust the calendar.
Well, we have per diem judges now serving in that capacity.
That's correct.
It almost renders the nomination moot for an undetermined period of time.
I wouldn't say moot. I would say it's certainly something that any judge who has a potential conflict in any case would be required to recuse themselves.
Well, if they have a neighbor in front of them on a drunken driving charge, or the husband in the divorce cases coached my son's soccer team, not if it's the county prosecutor's office. Is that fair to say?
I'm not.
I think, okay. Yeah, I'll stop.
I'm sorry. I'm really not
Yeah,
in the position.
thank you. Thank you, Chair.
Members, other questions? Really?
Well, I'm done with the judiciary.
I'm wondering if you
Sarah
can
Costa,
address
go ahead.
that, if you can address that
Yeah, I
in the sense, yeah, yes.
And we're talking about addressing Senator Keoho Kolole's question?
Yes.
Yeah, so, back when I was a per diem judge, my partners, Dan Hempy and Craig DaCosta, who you heard from, we're all appointed per diem judges at the same time, and we're also all criminal defense attorneys. So at that time, they separated it out where when we were sitting as per diems, we were never presiding over a criminal calendar because they didn't want there to be that appearance of a conflict. We now have two family court judges, or district family or district court judges, that handle the family court calendar. Presently, Judge Char doesn't do any criminal cases because she was a public defender, and so she cannot do criminal cases for that time period. So in talking to Judge Valenciano, we're able to, if this was an issue, I believe they will be able to take the calendars from the two different courtrooms that handle the family court matters and make it where there's enough of a calendar. Let's just say if I was confirmed for me, where we wouldn't have this issue that you're talking about, and still have enough of a calendar for Judge Char. She's gonna be up on her 2 years pretty soon here, I believe, and then she would be able to take over criminal cases. So I think there is a way, and there's also District Court Judge Thune that, potentially, as Mr. Miley was saying, they could adjust the calendars.
Okay. Other questions? Let me ask a couple and then I'll come back to you. Okay. Mr. Trask, are you still there?
Yes, yes, Chair.
Well, thanks. So it looks to me like the essence of this complaint is that the deputy prosecuting attorney in Kauai doesn't believe that the defense attorney should be able to talk to complaining witnesses. Is that true? Should they not be talking to complaining witnesses?
Absolutely not. I unequivocally, I say no. I think there is an ethical obligation because, unlike any other legal case, the complaining witness is not a client of the prosecutors. So in a civil matter, or if you're the criminal defense attorney, someone's represented by counsel, you don't speak to them unless you speak to counsel first, especially in crim because, the Fifth Amendment and all that constitutional protections. When I was a prosecutor on Kauai, that would happen all the time. I mean, for better or worse, domestic violence cases frequently have recanting witnesses. It was nothing I was not unfamiliar with. And then my understanding is that this case was a misdemeanor assault 3, so it was a fight between 2 adult individuals. And one person, I guess wanted to drop the charge, so you have to do it. When I was a defense
Right, so
attorney,
you have to talk to all the witnesses.
yeah.
Okay.
And I'll just say too, I always spoke recanting witnesses when I was a prosecutor, and they, you tell them, look, I'm not your lawyer, and if you go up and change your story, I'm going to impeach you. But that's just par for the course. And I think it's bizarre that you would then bring a charge against the attorney versus just impeach the witness. And this seems really weird. 6 months ago, there was a plea pursuant to it. I just don't get it.
Okay, so but doesn't a defense attorney run some risk in that situation that they're going to end up being somebody that the prosecutor's going to want to call as a witness if you get too involved?
Well, being a criminal defense attorney is a risky business. I'm just going to say that. I mean, your clients tend not to be, they call you for a reason. You know what I mean? Yeah. It's the criminal industry is a criminal industry. Yeah. I think there is, but in this case, considering there was no charge, right? I mean, this happened all pre-charge. Nothing happened. There was nothing really there. I think Greg did a good job dealing with an issue before it even started. Probably saved his client. Sorry?
Let's say that it got to the point where the prosecutor wanted to call the defense attorney as a witness. That's still not an ethical violation though, right? You just have to withdraw as that client's attorney.
Yeah, but also too, that's another kind of like a chess move that I think is in poor taste. It happens sometimes, and then you motion with the judge, look, that's not appropriate. There's a lot of kind of dirty pool that goes on sometimes, unfortunately. I'm not saying anyone's done that because I don't know enough about this case, but people try to disqualify you, and then you if it's true, you do what you got to do. If not, you represent your client.
But being disqualified in that situation is not a violation of the code of professional ethics.
No.
It's a conflict, basically.
Yeah, and then you move on. If it's a PD, you get another court-appointed counsel, or they got to get another attorney if they don't qualify.
Yeah. Okay. Okay. Thank you very much. Other questions? Senator Fazella, go ahead.
Sorry, we're not going to talk about that. But anyway, after serving as a Hawaii student and language teacher, why did you decide to go into law school?
I'm sorry, is that to me?
Oh, not for you, for him. Sorry, not for you.
I'm sorry.
Oh, sorry, you exchanged anything? I just.
Yeah, no, this is.
I know we're talking about, but we're not going to get to talk.
Right,
we're not
right.
Get to give his speech about him, and I understand we're talking about this. It's all G, but right now, getting to the point of that.
Yeah,
he never even give his presentation.
I hear you. No, it's unusual.
Right
it's unusual. I don't usually do it this way. So let's wrap up on this topic and then we'll go and then we'll let you have your opening statement. And we can talk about other stuff.
Okay,
so go ahead.
I have a question for the HSBA.
Are you still here, Ms. Sheldon?
Yes, I'm here.
So, the chair already cleared up that you were notified of the ODC complaint on Monday, and then the HSBA committee interviewed the nominee on Tuesday, so they were aware of the whole, I guess, the context around the situation. That's correct?
Yes, except for the first time that the Hawaii State Bar Association Board of Directors was informed about the ODC complaint, as well as the filing of the police report, was on Tuesday, June 14th, immediately prior to Mr. Myers' interview.
Okay, so they were aware of the criminal investigation as well.
Yes.
Okay. Because I guess the reason I bring this up is because the ODC process is pretty unknown to people outside of legal circles. But if what the supporters of the nominee are saying is true, is that, these actions are being taken in an attempt to impugn the character of a judicial nominee, the use of the criminal process to do that seems quite serious. And, if either inquiry, ODC, or criminal results in action taken against the nominee, I think it's fair to say that that would probably significantly impact the nominee's confirmation. The question is, if both inquiries are conducted and the nominee and no action is taken on the nominee, will there be some sort of investigation to determine whether this attempt may have been malicious? A malicious attempt to co-opt the legislative process to impugn the character of another attorney?
I can't reveal what the HSBA board discussed, but I don't think that would fall within the jurisdiction of the HSBA board to conduct an investigation as to whether this, filing of the police report was done maliciously. I think that would probably be in the hands of Mr. Myers.
Okay, thank you. Thank you, Chair. I'm done.
Sir, we get somebody from the prosecutor's office? Is somebody over there?
No, he didn't come.
Because I know I'm a rocket scientist or anything, but it's all what happened in December of last year.
It started in December
Yeah,
last year.
the timing. It just bothers me. I'm sorry that I don't know all the legal jumbo, but I just thinking to myself, I don't want to use those words, but it's more political campaigning smearing than just try to find a perfect person to do the job. And that's why I went out of turn and tried to go into the other subject.
We'll go into another subject.
Yeah,
I have one
sorry
more,
about
I have one more question I want to ask before we go to the other subject. Mr. Miley, do you mind coming back up again? So, the Judicial Selection Commission brought down a list, I don't know, 6 weeks ago or something, and Chief Justice Rechtenwald had to decide which off that list would be the one he would recommend to us. Are you at liberty to say whether or not CJ knew about these allegations at the time that he was doing the evaluations?
I'm not privy to his deliberations, but my understanding is that, and through my conversations with Mr. Meyer, that CJ was aware of the outline of some of the concerns. But back then, I believe, before Chief Justice Rechtenwald had made his final decision, I believe that there were no charges or no processes that were formally invoked at the time.
Okay. All right. Thank you very much. All right. And members, if there are no other questions on that topic, we'll go ahead and move on. Thank you, Mr. Miley. And you can, we'll go back to sort of regular order and you can make your opening statement and we'll talk about other stuff.
Thank you. Appreciate it. Thank you, Chair Rhodes and members of the Senate Judiciary Committee for this opportunity. I'd like to tell you about who I am and what I represent. I have lived in Hawaii for 20 years. I started my career working at Legal Aid Society of Hawaii as an AmeriCorps attorney in Hilo before being transferred to Kauai to manage the legal aid office in Nihui back in 2003. Kauai is where I met my wife, put down my roots, and started my family. I have always been involved and ingrained in the community. I have been a part of many different nonprofit boards and have served as president of the Friends of the Children's Justice Center, JDC Public Access Television, and Niamalu Outrigger Canoe Club. I am currently the treasurer of Haleopio, a nonprofit dedicated to helping at-risk youth on Kauai, where I also serve as a teen court judge. And I am on the board of Junior Achievement of Hawaii, an organization teaching financial literacy and entrepreneurship to our keiki K through 12. Finally, I've been coaching basketball in the community for about 15 years. I value my time in all of these roles, continuing to have an impact on my community and the people of Kauai, including our youth. I believe that if confirmed as a judge, I'll be afforded even more opportunity to have an impact on the community. I'll be able to help people move forward through difficult and challenging times in their lives with the ability to fashion remedies that can hopefully improve their situation. I have always prided myself on my ability to create relationships with all different kinds of people, including the ability to adapt to the culture around me. I know this will help me relate to the litigants and attorneys that would come before me if I were confirmed, as well as the staff with whom I would be working. I believe in finding solutions and trying to maintain positivity, especially during life's toughest moments. I firmly believe that if confirmed, I will uphold the virtues of being a judge. 1, being respectful and courteous. 2, making prompt and explainable decisions. 3, deciding impartially and independently. And 4, remaining composed and unimpassioned on the bench. With regards to the allegations that I acted unethically, I have not violated any ethical rules, and I am confident I will be vindicated through the ODC process. I realize this puts the Senate in a difficult position, but I can assure you that if I am confirmed as Kauai's next judge, I will make sure that I act diligently with full understanding of the responsibility of a judge's authority and the importance of integrity within the judiciary. The people who know me and who have worked both with me and on the opposite side of council table from me, and those who have appeared before me when I was a per diem judge, told HSBA some of the following things about me. Sticks to his word, helps his clients solve problems and not create them, and maintains a good reputation in the legal and local communities. Candid, straightforward, and honest. Has an inquisitive nature and desire to continue learning. Has a methodology for seeking answers to complicated questions. Has ability and enthusiasm to listen, keep an open mind, and objectively consider what he hears. Acts like a judge should act, thoughtful, fair to both sides, but considerate to attorneys and parties. Very compassionate when dealing with pro se parties. Level-headed, even-keeled, kind. Never gives you pause to question his character. Compassionate and fair. Humble, has common sense and is decisive. Very calm and compassionate. Legal aid experience allows him to be able to communicate with all types of people. Pigeon is excellent. Does not have a big ego and is not arrogant. These are all attributes that I know will help me ensure fairness, integrity, and impartiality in my rulings, all the while making sure the litigants are being heard and receive their access to justice. Thank you.
Thank you very much. Members, questions? Well, I'll start out then. A substantive question. You know, we hear in the news all the time about individuals who have been convicted multiple times of usually fairly low-level crimes, petty misdemeanors, but the sort of the conventional wisdom at this point is that judges just let them out way too soon, and it's just a revolving door. What do you do when you get a you know, for the facts of the case in front of you? I get it. You're not supposed to look beyond the four square of what's there, but for the sentencing part of it, you do have some discretion, or you will have some discretion if you're confirmed about how long to sentence people. What do you tell people? What do you tell the average guy who says judges just turn everybody loose right away?
Well, it certainly hasn't been my experience as a criminal defense attorney and being in the courtroom. And I know this is something I spoke about with Senator Keoho Kalole when we talked, and I spoke a little bit to you about it as well, Senator Rhodes. I'm not here to tell you that I have the magical answers, but I know that I will watch and see what would happen in my courtroom. I know I've talked to some of the judges on Kauai about this, to the extent they know who are these, I guess you guys call them frequent flyers. You know, you gotta, I do think you need to look at it on a case-by-case basis, but you also understand the person's record that is being brought before you. And what I hope is that there are other remedies, you know, that may be available to help these people, you know, advance out of the system, and you know, maybe that's me just being hopeful, but, and trying to be positive, but perhaps there's other things that we're not looking at. Maybe jail is not the answer. Maybe there's some kind of mental health program. Maybe there's some kind of other diversionary program. I know we used to have a diversion program on Kauai that was headed up by Judge Senda. Not sure exactly what happened to that, but, and I think it was mostly with mental health clients. There are also people, we have a contempt of court program, Project Contempt. So potentially there are other avenues than jail, but if jail is what's needed, then that's what's needed, and I got no problem with that.
Okay. Senator Casio, go ahead.
So just kind of to follow up on that in the flip side, but you did allude to some of it, and I wanted to, my question to you was going to be about this specifically. Alternatives to incarceration. There is much evidence, like with culture and INA-based programs, and like you mentioned, mental health, drug treatment, et cetera, that show recidivism rates dropping. In your community, as a judge, it would be your obligation to make sure you're aware of those programs. And I just wanted to ask, what is your engagement with that? Are you connected with the programs? And also then larger picture is, how do we create more?
Okay. So the first part of your question, and in my role, if I was confirmed as a family court judge, it's my understanding I would be taking over Judge Akoba's calendar as things are presently situated, which includes the domestic abuse calendar, as well as the juvenile delinquency calendar. So I'm involved, I represent teens. I'm also judge of teen court. So that is a diversionary program, teen court. For teens that get in trouble, they go through this other program, actually, where we have you're sentenced by a jury of your peers. There's almost like a mock court. The teens volunteer to be attorneys also for their peers. So that's a diversionary program for juveniles. There are lots of diversionary programs actually for juveniles, and resources, especially for teenagers getting into trouble. For the adults, I'm familiar with our domestic violence programs that we have. I've always thought, though, in my clients, when I represent them, I've always wanted them to get more out of it and not just go through the motions of going through this 26-week class. I've tried my best to set my clients up with one of our private, I guess you call him a therapist, but he focuses on anger management. There's a specific person that we use. Each and every client I've sent through him, he's actually a former addict, this person, and he was actually involved with the Veterans Court on Kauai before he went into private practice. Each and every person I've sent through him has gotten something out of the sessions. And that's what I would hope I would be focused on as a judge, trying to help these people get help that they need. With regards to the second part of your question, I have experience writing grants. I don't know what the role would be as a judge, but at Legal Aid, we wrote a lot of grants to help us get support to go represent people. Back then, we were going and teaching to the pregnant teens and teen parents in the schools. So I know my way around helping with that and writing grants. And it's something I actually discussed with CJ in my interview, this idea of, if someone's doing a program somewhere else, another state, another jurisdiction that we think is good, let's do it. And I know not necessarily in the criminal context, but I know we've looked at that in terms of child protective services cases, trying to model a program that's done in another jurisdiction. So I'm all for that.
Yeah. Okay, awesome. Thank you.
Other question, members? Senator Pavella, go ahead.
Kind of staying on the same topic, I got a question. So not so much maybe in Kauai, but I give you an example here on Oahu. So HPD goes to the park, issue out a ticket for being in the park after dark, illegal camping, whatever activities that is happening in the park. On the ticket, it has your court date and information. Not saying all of them is doing this, but most of them is doing it because the homeless tell us. They get a ticket, they don't show up for court. Then they get time for giving a warrant out for their arrest. The judge throws it out because there's no actual address to send them the information second time. So I didn't understand the fact of the ticket you have has the warning on it and the court date. Why do the judges expect to have them have a physical address knowing that it's at the park? So when they was using the park's address, they're saying that they didn't get the information to show up court. So they don't issue out bench warrants. So the officers that was doing this for a while was wondering why, when they go up to this individual that been there for 5 years, there's no bench warrants. Then they find out that majority of the judges was throwing out the bench warrants because they say that it wasn't a physical address that they could send them when they come to court. Now, I don't know if you guys have that problem in Kauai, but we're having this explode here on Oahu. And these guys are not getting bench warrants because the judge is saying, oh, they didn't come to court, but they didn't get the mail to appear in court. But what we're saying, and law enforcement is saying, that getting a ticket with the information on your court is your information to come to court. So I just want to know if you guys have something similar like that. In Hawaii, if somebody's a repeat offender, but because they couldn't give them another court appearance date, you guys throw out the bench warrant.
So my understanding is the same as your understanding that, you know, clients come to me, they have the citation, gives them their court date. That's when they need to be in court. Otherwise, they run the risk of a bench warrant though. But to answer the question as to whether we have that issue on Kauai, I'm not, that would be more of like a district court. I'm not in district court all the time dealing with those people. I'm there representing my clients and I would see those people coming through, but I'm sorry, I wouldn't have the information to know whether that's going on.
Thank you.
Other questions? Okay, I did have one other one. It looks, you're saying that you expect to get retiring Judge Akoba's current docket, which I believe includes the special calendar for family court. Is that correct?
I believe that's correct, yes.
So Assisted Community Treatment Act petitions would come through you. You know, basically assisted community treatment says it's just, there's a bunch of legal hoops to jump through, but if a psychiatrist says this person needs medication and they're a danger to themselves or others, then as a judge, you can order them to take their meds. Do you have any problem with ordering someone to take their meds if the psychiatrist says they're mentally ill?
No problem. And I believe Senator Rhodes, you and I talked about this a little bit and I've seen it happen. I took another look at that statute and I noticed how comprehensive, I think I mentioned to you, it's quite a comprehensive statute. So if it's reached that level and they've met those criteria, I don't have a problem following the law in any respects if the law says it can be done.
Okay, thank you. Anything else, members?
Let me go back to my question that I guess I'll ask them at the wrong time. After serving as a Hawaii studies and language teacher, why did you decide to go into law school?
I was never a Hawaii studies and language teacher. Are you sure? Did I write that
Oh,
somewhere?
okay, I have that down over here. Sorry, wrong guy then. Okay, let me go to the one, maybe it might be you. Okay. As a prospective judge, what would you do and consider the greatest strengths and your weaknesses?
I'm sorry, say that again. What would I
As a
consider?
prospective judge, what is your strengths and your weaknesses that you would bring?
My strengths and my weaknesses. Okay, great. So I think we've talked about a little bit about that. I think compassionate, understanding. What I believe in most and first and foremost, I think all the senators that I talked to leading up to this hearing, I talked about it, is respect. You know, I think just in life in general, too much of us don't respect each other. And I always thought that if we just show a little more respect to each other, we'd all be a little bit happier and life would be a little bit easier. So I think that's something I'm going to ensure that happens if I'm confirmed in my courtroom, that we're all showing respect to each other. And I think I'm good at doing that. And I'm an excellent listener. I believe everybody needs to be heard as part of this respect thing. Not only heard, but actively listening, you know, not just letting them talk, but actually paying attention to what they're saying and commenting appropriately. You know, in terms of my weaknesses, we all have weaknesses, right? Sometimes people say I'm a little too emotional. I don't think, you know, people know me as an attorney and then people did appear in front of me as a per diem judge. I know how to play my role differently. I was just talking about this earlier with some of the other candidates. You know, we all play different roles in life, right? So there's a role of parent, right? There's a role of coach, there's a role of judge, a role of attorney. And so, you know, you gotta behave and what is the word I'm looking for? You gotta act as it would be appropriate in the role that you're playing. And I think I'm pretty good at that. So even though I can be emotional, I know when to turn it on and turn it off.
That's one. So what would be your vision as a future in the judicial system, and what changes you think you advocate like, I guess, changed to advocate and why?
I think one of the things that I've been thinking about and part of what I talked with the CJ about in my interview, and I believe I talked to some of the senators about it, and part of what Senator Ocasio was talking about, I would like to see more programs available at the judiciary, whether we're talking about criminal or whether we're talking about civil cases. I would, if confirmed, I would be handling custody matters. In the old days in Kauai, the court itself used to provide an individual who would do a social study at no cost to the parties. Now we have a lot of parties that can't afford to go hire attorneys, and then they can't afford this thing we call a guardian ad litem or a best interest fact finder to go do an investigation, which assists the court actually. In other jurisdictions, they have these kind of things. They call it a friend of the court. I would like to explore this opportunity for Kauai. We do have something called a kokua kanawai, which is a helper of the court. More so we see that in the guardianship cases. But I would like to see more programs, and I'm happy to, you know, what I would like to do, if confirmed, observe what's going on and observe what's happening and see where the pratfalls are to try and make sure we're running an efficient system. I know the CJ is always talking about access to justice. As practitioners, we know how inefficient it can be sometimes for our clients. As painful as it is, and to have things put out further and further, it makes it for let's just say a not positive experience for the litigants sometimes. So I would hope to focus on that and trying to make sure that, you know, we're running an efficient system that has available programs.
Thank you, Chair.
Thank you. Any other questions? Senator Gabbard.
Yeah, I'm sorry, I may have missed this earlier, but Mr. Myers, when did you become aware of the negative testimony that we talked about earlier?
Was the day before I met with the HSBA, and I met with Shannon Sheldon and Pat, the executive director of HSBA.
Was that on Monday?
Gosh, Senator Gabbard, the days are all running.
Yeah.
Let me give it some thought. I think it was Tuesday, and my meeting with, no, what is today? Thursday? Yeah, I think it was Monday, and my meeting with the HSBA was Tuesday. That's correct. Yeah, Monday. I
Okay,
learned
the
it.
reason I ask is because we had our courtesy meeting on Monday at 11 o'clock, and I had asked you at that time if you could think of anything that would negatively affect your appointment, and you said you couldn't think of any. So will you?
I was not aware of it then, and just
Double checking.
yeah, in fairness to me, I spoke to Senator Rhodes and asked him, should I contact all the senators on the committee about this? And it was my understanding that it was not something that I needed to do
I
at that
didn't think
point.
you needed to go back around, so
Yeah.
that if you're gonna blame,
No,
if you're gonna hold them against that, hold it against.
Because I knew that I told all of you, you guys all that I talked to, you all asked me the same thing. And then I'm like, oh my gosh, Senator Rhodes, should I be calling these people and letting them know? Because I just found out about it myself.
Just clarifying. Thank you, Chair. Thank you.
Okay, other questions? Senator Sokolow.
So the community on Kauai is small. And without making too many assumptions, well, without going too far into it, I would assume the individual or individuals who were responsible for the complaints coming out and the timing in which they came out are known to you and are potentially individuals who might come before your court if you're confirmed. Are you going to be able to be impartial after having the week you just had?
100%. I'm not a very vindictive person. My wife is there in the gallery. If this was her, maybe it would be a different story. But
I'm not asking what your wife would do in 500 years if she were to walk us in front of these people.
I'm not vindictive, and I know that's not the judge's role. The judge's role is to be impartial. The judge's role is to be fair and diligent and independent. It's, you know, whatever happened. If I'm confirmed, I'm moving forward, and I think actually it's one of my strengths. I'm able to move forward. You know, I live in the present, and you know that whatever happened in the past happened, but it's not my role as a judge. My role as a judge is to listen to the people that are before me, assess the situation, assess the credibility of what I'm being told, and make a decision, and make sure I can explain my decision and make sure my decision is prompt and impartial. And I'm 100% confident I can play that role despite everything that I went through this week.
Okay, thank you.
Okay, thank you. Members, anything else? All right, thank you very much. We're gonna take let's see, what time is it? We'll take a recess until 11:40, and then we'll continue on with JC 2, which is Joanna Sokolow. Anyway, in recess until 20 till 12.
Thank you.
Okay, coming back in on our Judiciary Committee meeting, looking at and confirming judges. Next up is Judiciary Communication number 2 for Joanna Sokolow, submitting for consideration and confirmation to the District Family Court of the Third Circuit for a term to expire in 6 years. Okay, testimony on JC2, Donna Payesco is in support. Dawn Laird and Terry Lee Fujioka Lilly are both in support. Milani Fujimori Kaina in support. Catherine Gibson in support. Noah Gibson in support. Earl Edward Aquino in support. Joseph E. Cardoza in support. And Shannon Sheldon, HSBA president, I think is zooming in. Yes. Morning again. This is still morning, yeah. Go ahead.
Morning. So thank you, Senator Chair Rhodes and members of the Judiciary Committee. On behalf of the Board of Directors for the Hawaii State Bar Association, we found Ms. Joanna Sokolow qualified, and we stand on our written testimony, and I'm available for any questions. Thank you.
Thank you. Members, any questions for Ms. Sheldon? Thank you. A thing that I'm forgetting to do then, now that we're live again, is there anybody else here who wishes to testify in JC2? Okay, seeing no one, Judge Sokolow, if you could please come up and go ahead and make your opening statement. Good morning.
Morning. Good morning, Chair Rhodes, Vice Chair Hasegawa, Senators Ocasio and Gabbard. Thank you for taking the time to meet with me over the past few weeks. It has been my pleasure meeting with you. I chose to go to law school because I believed it would arm me with a set of technical skills that would allow me to help as many people as possible.
Sorry to interrupt so soon. Can you just pull the mic closer and straight? Yeah, thank you.
And you've seen from the information you've received about me that I've devoted my legal career to providing direct legal services to low-income members of the Kona community. I came straight to Kona from law school 16 years ago. My husband and I were welcomed into our community, and we've always tried to interact in ways that are respectful, humble, and that give back on the many blessings that we've experienced in Kona. We own a home and have 2 children who were lucky enough to be born in Hawaii, and they attend a public school that they love and are excited to go to every day. My husband's a public school teacher and has taught at the same public charter school for the last 16 years. During my legal career in Kona, I have gained trial experience in family court, district court, and circuit court. First, as an attorney with the Legal Aid Society of Hawaii, I provided critical legal services to the low, moderate income and senior citizens of Kona. I had countless trials and evidentiary hearings in the family court where I went up against private attorneys and pro se's. At Legal Aid, I gained experience in divorces, custody cases, restraining orders, child abuse and neglect cases. Then at the Public Defender's Office, I gained even more courtroom experience, not only in jury and bench trials, but also in research and motions practice. At the Public Defenders, I carried my own felony caseload, but also covered district court in Waimea, veterans court, and juvenile drug court. I also worked in the family court while at the Public Defender's Office. I covered the family court criminal calendar, involuntary hospitalizations, and the juvenile delinquency calendar. After the Public Defenders, I worked at a nonprofit children's advocacy firm called the Children's Law Project of Hawaii, where I returned to the civil side of family court. At the Children's Law Project, I acted as guardian ad litem and parents counsel in abuse and neglect cases, and as an attorney representing petitioners in guardianships and adoptions. Last year, I was honored to be appointed per diem judge of the family court. As per diem, I presided over divorces and covered restraining order and criminal calendars in Kona, Waimea, and Hilo. including trials and evidentiary hearings. While a per diem, I started an LLP with Catherine Gibson and continue to take only court-appointed criminal cases. So while I'm technically in private practice, I have stayed consistent in my commitment to serving the low-income and underserved in Kona. I've also been consistent in my volunteer work, which I started when I was 14 years old. My volunteer work in the legal community includes being a current commissioner on the Access to Justice Commission and chairing one of their committees. I've also worked extensively in South Help, Kids First, Courts in the Community, Law Week, and more. Beyond the legal community, I've also volunteered in civic organizations, on boards, and in other capacities. One example is at the beginning of the COVID-19 pandemic, I collected legal information from various organizations, created leaflets and Xeroxed those and dropped them off to organizations that were doing food drops. I also actually assisted in some of those food drops, preparing the bags for people, and then actually coming to those events and providing legal information about domestic violence where necessary. I applied to be a family court judge because I see it as an extension of the public service I've been doing throughout my career. I also see it as an opportunity for intervention for at-risk children and teens. If confirmed, I pledge diligence and hard work to learn the things I do not yet know. I pledge to take each case with new eyes and apply the law to the facts without bias. I hope that my legal experience, my volunteer experience, and my life experience will put me in a position to help solve problems. If confirmed, I will endeavor to continue my work on the Access to Justice Commission and any judicial committees that need my assistance, and continue to serve a community that has given me so very much. Thank you for your time and patience.
Thank you very much. Members, questions? Well, similar to the question I had for Mr. Meyer, it looks like you might at some point be have the special calendar on your docket. So back to the Assisted Community Treatment Act. If a psychiatrist says this person is a danger to themselves or others, they're unaware of their psychiatric condition, and we request that you order them to take their meds. Is that something that you're willing and able to do?
Yes, definitely. So long as the statute's been followed, I don't have a problem doing that. As similar to Mr. Myers, I have had clients who have had that happen, so I'm familiar with that process. And no, I have no problem doing that.
Okay. Also similar to Mr. Myers, well, it's the defense side, the criminal side of family court, of course, is limited, but if CJ at some point switched you over to district court, which of course he has the authority to do, same question about the multiple, low level offenses that we see sometimes. In my opinion, the judiciary is losing credibility because of the fact that people feel like people are just rotating through, and you get somebody with 40 or 50 convictions. What do you do? Why not? Or maybe I should say it the other way around. Why not hit them with the maximum penalty for whatever the crime is that they've been convicted of most recently?
Well, HRS 706 provides lots of guidance as to what is appropriate when considering a sentence. Certainly, the punishment should reflect the seriousness of the offense, but you also have to look at a person's background. Oftentimes, if somebody's a repeat offender, it can warrant a longer sentence, sometimes double the prior sentence. I've seen that happen. But you also have to look at each particular case and each of the factors. I'm sure that you all know that the prosecutor has the discretion to charge somebody with a felony if they are a repeat offender. And so that is something that is not the court's kuleana. It's, the prosecutor's the one to decide whether to do that or not. But certainly I would look at each defendant before me. I would look at their history. I would look at what we've tried so far. As Mr. Myers mentioned, that there are people with serious mental illness and substance abuse issues, and those could be addressed in other venues. I think diversion programs are excellent. They work very well, especially when there is a social worker or case manager to make sure that people get to their appointments, take their medication, and engage in services.
Okay. Questions, other members' questions? Senator Favela, go ahead.
Right now, there's a situation, in my community. Person is early stages of dementia. Gotta get in touch with the family. Put in a case with adult services, letting them know, on the health and welfare check, that simple things that we had asked, show that he has not just being lonely, but early stages of dementia. Call HPD to make sure there was witness to the interview or the presence of us being there. What can we do? I mean, as not only as legislators, but as judges and in a family court right now, for me to go over there to you or to the family court with this information, right now it's lacking. I see that there's a big lack on the adult services intake, not the people that running them, person that doing the intake. Because I think I gave enough video, I gave pictures, and I think I gave enough information to the intake person on the situation that he is now fall victim of having about 179,000 taken out of his bank. And now the bank is now frozen his accounts. Two individuals who are supposed to be the caretaker are drug dealers using his money to buy drugs. All this information was typed up, given to adult services. The intake person couldn't get in touch with me. When I did try to get in touch with her, she was on vacation. So 3 days after my complaint, she dropped the complaint. She didn't go further and investigate. So I called her, the director and the supervisor, and asked them why. So they didn't see why she had dropped it because I gave enough detailed information. But as a family court judge, what else is there for the public to do when there is cases like this, that we have an entity that's between you guys and us trying to get this person the care, because we see the deterioration and the abuse of the people around him, using his car, smashing his car, and took over his cottage and selling drugs. Now the community is frustrated, HPD is frustrated, but there's nothing we can do because the agency didn't send nobody out to find his family in Maui or even to go and see this guy. And even in the police report, it's also said that the individual supposed to be his caretaker sound like she's guiding him what to say, right in front of the police officer. They got that report too. They did not initiate a case. They decided to dismiss the case. So I'm still following up with the other supervisors to get this guy help. Reason why I'm saying this, he lives by the beach. He wanders at night. There's a lot of potential of harming himself or others harming him. So besides adult services, what we can do as not only legislators, but as individuals to help someone like that in our community when they need that kind of help. And HPD did what they could do. We did what we could do. Now we're relying on an agency. You know what I mean? I mean, we just same thing with the young kids with child family, you know, with abuse of a child. But what can we do as maybe your experience that we can do as individuals to bring it further to you guys?
Well, thank you for that question. That's a really difficult situation. I'm sorry you're going through that. As you may know, anybody can petition for a guardianship for a vulnerable adult. And so, you know, you could nominate, a person could nominate another person to be a guardian, or could nominate the public guardian. The Office of the Public Guardian does provide guardianships for people who don't have family members to act as guardians. So that's one thing. The other thing is that, you know, restraining orders could be obtained against people who are taking advantage of a person or their belongings. And then, you know, that continue to file police reports, things like that. But there are avenues available. Unfortunately, that's an extremely difficult situation. And, you know, I hope that person gets relief.
Thank you, Chair.
Thank you. Members, other questions? Okay, you're off the hook. Thanks very much.
Thank you.
We'll move on to JC number 1. Jill M. Hasegawa, for consideration and confirmation of the District Family Court of the Third Circuit for a term to expire in 6 years. First up, we have James Wilston in support, Nancy Kriegman, Chief Executive Officer for Domestic Violence Action Center in support, Alexa D. and Fujisa, Judge retired in support, Brandon Cariso in support, Randy Liu in support, Lynn Jenkins McGivern in support, H. Shan Wirt in support, Tracy Wilkin in support, Douglas Helsted in support, Hanani Burns in support, Dawn H. Laird in support, Simi Nakoba Jr. Justice retired in support, Ken Hayashida in support, Milani Fujimura Kaina in support, Kevin Adania in support, Joseph K. Kamalamamela in support, and Arnold Kishi in support. We also have Noah Gibson in support, Tom Tanimoto in support, Jennifer Zelko Schluter in support, Laura Knudsen in support, Levi Ho'okano in support, Mihoko Ito in support, Joseph Cardosa in support, Gemma Rose Poland Soon in support, and Trisha Nakamatsu in support. Is there anyone here that wishes to testify on JC1? Okay, if not, we'll go ahead and go to Shannon Sheldon, HSBA President. Good morning.
Good morning again, Senator Rhodes and members of the Judiciary Committee. The HSBA Board of Directors has found Ms. Jill Hasegawa qualified for the position and submits on his testimony. If there's any questions, please let me know. Thank you.
Thank you. Members, questions for Ms. Sheldon? Seeing none, Ms. Hasegawa, or Judge Hasegawa, please come up. Good morning.
Good morning. Good morning, Chair Rhodes, Vice Chair Keohokalole, Senator Ocasio, Senator Gabbard, Senator Favela. Thank you for this opportunity to address the committee. I was born and raised in Hilo on the island of Hawaii, and as the oldest of 3 girls to parents who are both attorneys on the Big Island. My father opened his law firm in the early 1980s and continues to serve the local community with their legal needs. My mother has worked as an attorney with the Child Support Enforcement Agency, first with the County of Hawaii and now the Department of the Attorney General's Office for over 40 years. Being the child of 2 very hardworking attorneys, my grandparents played a huge role in my upbringing. My grandfather, Niwao, who was born and raised on a plantation in Pauhau, but graduated from Hilo High School and went on to attend Carnegie Tech, now Carnegie Mellon, in the 1930s and served as an engineer for Helco. My grandma Niwao, who grew up in Lahaina and at an age when higher education was unheard of for females, adventured out first to California and then to Michigan, ultimately graduating from the University of Michigan, and went on to become a teacher at Hilo Intermediate School. And on my father's side, my grandmother and great uncle who persevered during the war. And when my great grandfather was sent to a war relocation camp in Santa Fe, New Mexico from Hilo, my great uncle was drafted. My great grandmother continued to work hard to maintain the family business, which would become known as Hawaii Junk. My grandparents would pick my sisters and I up from school, help us with our homework, shuttle us to all of our activities, and take us traveling around the world, introducing us to new experiences. Through their examples, I learned hard work and to challenge myself and embrace new adventures. I also learned the importance of compassion, serving our community, and giving back. I am a proud graduate of Hilo High School. After graduating from Hilo High School, I left Hawaii and attended first the George Washington University in Washington, D.C., and then returned home to Hawaii to obtain my Juris Doctorate at the William S. Richardson School of Law. Following my graduation from law school, I spent approximately 13 years practicing on Oahu with the law firm of Ashford and Riston before returning home to the island of Hawaii. During my time at Ashford and Riston, I focused my practice primarily on family law, handling divorces, paternity, interstate child custody and child support proceedings, domestic TROs, adoptions, guardianships, and a few CPS matters. I also represented our firm's financial institution clients in collection and foreclosure proceedings, as well as handling a few landlord-tenant and district court TRO cases. In 2012, I became a partner with the firm until I left the firm in 2017. In 2017, I made the difficult decision to leave the firm and all the close friends and colleagues I had made and return home to Hilo to help with family. At the time, my grandmother was 95 years old and living alone with the onset of the Alzheimer's and dementia. I'm very happy to say that she just celebrated her 100th birthday in January, and she's doing very well. And I'm so thankful for the time I've been able to spend with her. Upon returning to Hilo, I worked with my father in his law practice and shifted my focus to assisting his clients, which included more transactional work, such as estate planning, trust administration, probates, conveyance, and other matters. In 2019, I applied to be a per diem judge, and in 2020, during the pandemic, I was sworn in as a per diem judge in the Third Circuit, covering both the family and district courts. In the past year and a half, I have logged countless miles traveling across the island as I've regularly covered the Hilo, Kona, and South Kohala courthouses. I am so thankful for the invaluable experiences I have gained as a per diem judge. While previously I had only experience practicing in family court and handling district court civil matters, I learned to cover the traffic and criminal matters in district court. As a per diem judge, in addition to covering the district court criminal, traffic, and civil calendars, I also covered the family court divorce, paternity, child welfare service, juvenile, criminal, adoption, guardianship, and involuntary hospitalization calendars. Serving on both the east and the west side of the island required me to become acquainted with the different internal practices and procedures of the courthouses as well as court staff. Looking back at my calendar the other week in preparation for my meetings with various senators, I counted in the last 365 days, I sat as a per diem judge for over 100 of those days in both district and family courts, also balancing my private practice and volunteer activities. I am so appreciative of this opportunity to continue to serve my committee. Throughout my life, I have been passionate about helping my community and have dedicated my efforts to access to justice and public service. I see this as an opportunity to expand those efforts. Throughout my years of practice, I have been extremely involved with the Hawai'i State Bar Association. And in 2007, when the HSBA was undergoing its strategic planning, I was given the task of heading up a subcommittee looking at the issue of identifying and growing future bar and community leaders. Out of the subcommittee came the HSBA's Leadership Institute program, a value program which I remain involved with to this day. I also served as a mentor for attorneys with the Domestic Violence Action Center, providing instruction and guidance to the newer attorneys on a broad range of family law issues, as well as a volunteer settlement master with the Family Court of the First Circuit, a volunteer with the Kids First program, and a volunteer attorney with the self-help centers at the Honolulu District Court, Kapolei Family Court, and the Hilo Self-Help Center. When the Hawaii Access to Justice Commission was created in 2007, I was asked by then Chief Justice Moon to serve as the vice chair of the commission. I continued in that role at the request of Chief Justice Rechtenwald until December 2014, when my term on the commission concluded. During my time on the commission, I worked with other wonderful advocates to increase access to justice, encouraging attorneys to take part in pro bono opportunities, helping to recruit volunteer attorneys to staff the statewide self-help centers, and working to increase funding for civil legal services. Although I no longer serve as a commissioner, I remain active and involved with the commission's administrative and pro bono initiatives committee. My dedication to service has also included giving back to my alma mater. I have served on the boards as a director and officer for the William S. Richardson School of Law Alumni Association and the University of Hawaii Alumni Association, representing over 200,000 UH alumni, including as past president of both organizations. In that role, I work closely with the administration and alumni to strengthen ties, create support networks, and help current students. And I'm so blessed to have been given the great educational opportunities and feel a responsibility to give back and provide those same opportunities to our future. I would like to thank Chief Justice Mark Rechtenwald for placing his trust in me and appointing me to this position. I'd also like to thank those individuals who have submitted testimony before this committee in support of my nomination. I'm so honored by this opportunity to continue to serve my community, albeit in a different role, and humbly request the support of the Senate Judiciary Committee to allow me to continue to serve the people of Hawaii. Thank you for your consideration, and I'm happy to answer any questions you might have.
Thank you very much. Members, questions? Senator Casio?
I guess similar to the question I asked before, because I would imagine so what can you share some of your thoughts on criminal justice reform and how you as a judge, per diem judge, and if you're confirmed, can contribute to the conversation around the need to, the needs and what you see. And then on that same note, what are your interactions and awareness in the community as to programs that are in place as alternatives to incarceration that, again, for reducing recidivism and addressing the more systemic issues of that frequent flyer conversation, right?
Sure.
So bigger picture in terms of our reform, and if you can just address that.
So with regards to reform needed, I think it's a very important discussion to have, and it needs to continue. As a judge, I think we aren't really able to get involved so much in the day-to-day politics or creating that reform. But I do think that it's a discussion that needs to be had, and in order to have an effective resolution, it requires bringing all the stakeholders to the table to be able to discuss the various options. With regards to what programs are out there, first of all, with regard to, I guess, the frequent flyer discussion, I look at every defendant who comes before me as a separate individual. I look at all of the facts and circumstances surrounding their case. And to the extent that there are other programs, for example, if the underlying issue is substance abuse or mental health, I believe it is important to take advantage of those diversionary programs, because the goal is, again, to end the recidivism, to not have to see them again. And if you can address the underlying issues by sending them to the different programs or making sure that they engage in those programs as part of their probation or sentencing, I think that is very important.
Thank you.
Other questions, members?
Yeah, sure.
Senator Favela?
I think I'll give an example. So, talking about the frequent flyers. So we have a gentleman who's not from the community, he grew up in a community, but he's been in our park for 5 years. He knows the laws, he knows the rules, he knows certain things, but he sometimes get caught. Knowing that if he comes before you, I mean, of course, you're not gonna always have this person come before you. But if this person comes before you, he's not on drugs, he just don't want to do anything but live in a park. Knowing that he comes before you more than once or more than twice, how would you handle something like that? Knowing that the police know that, also the prosecutors know this, and some of the judges know this, but he's still in a park living every day. How would you address something similar like that?
Well, I think first I would need more information, but I think, again, you look at it on a case-by-case basis. Although drugs or mental health might not be a problem, unfortunately, with the high cost of living and houselessness or homelessness is a problem here on this side or in the state. And unfortunately, we do have people who are residing, have nowhere else to stay and are in the parks. And so again, I think you're looking at a totality of circumstances, and basically you're looking at not just what the offense is, but if there are any underlying issues that might be causing the situation.
So I guess what we're having here in Hawaii is that everybody's shipping their families houseless when they come to our community. So they need to be more educated in the sense of the rules of engagement. Yeah? This is the thing, the complexity that this individual has. He knows he's not on drugs. He just like be there. He knows where and when. But when is it would be enough that he's gonna come before you for the 20th time, being that person in the park, knowing that he has the history of being in that park over the time? What can we do differently? What can we do legally do different for individuals like this that come from another state and bring their knowledge on how to play the system? When they come before you a certain amount of time, when does, because everybody went helping now, everybody went there. Don't get me wrong, we had every resources you could think about, from feeding, churches, everything. You just don't want to budge.
Well, there are laws that cover that, and there are penalties that have been adopted, whether it's by the legislature or the county, if it's a county ordinance. And at some point, you basically, as a judge, it's my responsibility to follow the law and the sentencing required. And after reviewing all of the circumstances surrounding that individual, if it's not an issue that would benefit from diversioning programs, and then you're facing what the maximum penalties are that are allowed for under the statute or the county ordinance.
Thank you.
Thank you. Any other questions, members? Similar to the ones I asked the other two nominees, it looks to me like you have an interesting job in the sense that I understand that you're expecting to have sort of a split docket that's half district court and half family. Is that right?
So it is a true community court in the sense, South Kohala Courthouse, Waimea Courthouse. It is the district. It's in the district of South Kohala, but it's in Waimea. It is the true community courthouse where it handles both district and family court matters. And you have one judge. So we're talking in family court, oftentimes you use the phrase one judge, one family. In this case, it's one judge, one community. You'll see them in the district court side, but also in the family court proceedings. And I think that there is a lot of crossover in the issues that you'll see.
So in terms of the Assisted Community Treatment Act, I think you said you'd already done civil commitments. Of course, ACT is sort of a step down from civil commitment because you're not putting them in a building that they can't leave. But you're okay if the psychiatrist says this person's a danger to themselves or others and that they really need to take their meds to have any chance of recovery, you're willing to do that.
If the statute has been complied with and the psychologist feels it's necessary, I am willing to order that. And I have unfortunately had to order some involuntary hospitalizations in the past.
Yeah. So sort of following on Senator Favella's question. So when you have these cases where there's multiple convictions, not just 2 or 3, but 20 or 30, do you have access? There's a pre-sentencing report, right? Or it's called a sentencing report, maybe, I don't know.
I think in district court, we don't have necessarily the same types of reports that they would get in circuit court. We do have access to programs where we can see what their history might be, but not necessarily what sentences they might have seen or any of the facts or
can you see whether they've already been offered assistance, mental health or substance abuse treatment?
Not in the reports that I have seen as I sit on the bench.
Because that seems like an important factor, because if you get somebody with 30 convictions and they've already been offered or tried and failed on substance abuse, at some point, I agree with what you said earlier. You've got to just give them the maximum for whatever the sentence is, because it's just too disruptive for the rest of society for having to have someone who's constantly stealing or whatever it is that they're doing. So I don't know. Maybe that's something the judiciary can work on in terms of being able to show their judges what the person has already been through, because as I mentioned before, I think it's not just my community. People are really tired of guys just going in and coming out and just doing the same things over and over and over again. Okay, members, any other questions? Okay, thank you very much, all of you, for being here. And we are, I'm going to call it recess until Monday afternoon at Monday afternoon, no, sorry, Monday morning at 11:30 for the decision making, June 20. I'll start over again. Monday, June 20 at 11:30 in this room 016, we will have decision making on these three JCs. Thanks for being here.